The first sign was the orange spray paint. It appeared overnight, a series of lurid, fluorescent dashes and dots and cryptic abbreviations staking a claim across the back third of my property. They ran like a careless scar through the understory of the woods, cut across the corner of the old wildflower meadow my wife, Clara, had planted, and terminated at the serene, muddy bank of the slow-moving creek that marked the western boundary of my land. I stood there at dawn, coffee turning cold in my hand, staring at the vandalism. This wasn't surveyor's marks. This was something else. This was a declaration. My name is Silas Thorne. The land is 12 acres of what was once my grandfather's farm, now mostly rewilding itself around the sturdy old cottage where I live alone. Clara had been the gardener, the keeper of beauty. After she passed 3 years ago, I'd let the cultivated parts go, finding a painful sort of peace in watching nature reclaim its own. The land was my memorial to her, quiet and unkempt and real. To the north and east lay the coves at Silver Lake, a gated community of imposing, neo-colonial homes where the grass was a uniform, chemical green and the only sound on a summer evening was the hum of central air conditioning. The Homeowners Association there was a force of nature in its own right, led, I had learned through terse, impersonal letters, by one Karen Breckinridge. The letters had started gently enough. Friendly reminders about maintaining visual harmony and managing vegetative overgrowth to prevent pest harborage. I'd ignored them. My land was not part of the coves. The historical property line, a crumbling stone wall now mostly swallowed by ivy and blackberry brambles, was clear in the county records. But to Karen Breckinridge and her HOA board, my untamed 12 acres were an eyesore, a blemish on their curated perfection. The orange paint was an escalation. I found the notice taped to my mailbox 2 days later, printed on the HOA's heavy, cream-colored cardstock. It was addressed to owner of unimproved parcel adjacent to the coves, lot #G12. Asterisk notice of common area improvement and easement activation. Per covenants, conditions, and restrictions, CC&RS, Section 18.2, Shared Water Features and Drainage, the association is undertaking necessary improvements to the communal stormwater management system. This requires the installation of a secondary retention and pump station on the designated drainage easement within parcel G12. Work will commence on Monday the 14th. All vegetation within the marked area will be cleared. The association assesses the cost of this improvement to be a common benefit. Any interference will be considered a violation of the recorded easement and will result in legal action to recover costs and compel compliance. Asterisk. It was signed with a sharp, angular signature, Karen Breckinridge, President, Board of Directors, the Coves at Silver Lake HOA. Easement? There was no easement. My grandfather had sold the lakefront parcel decades ago, but he kept this back piece, this wooded slope, with no strings attached. A cold, hard knot formed in my stomach. They weren't just complaining anymore. They were invading. And they'd given me less than a week. My first stop was the county records office. An hour of dusty searching confirmed it, the deed was clean. No utility easements, no drainage rights of way. There was a vague, century-old mention about maintaining natural watercourse flow, but nothing granting the coves the right to build anything. I made copies, the photocopier whirring like a mechanical witness. My second stop was less productive, but more revealing. I drove to the imposing, faux plantation-style clubhouse that served as the HOA headquarters. Karen Breckinridge agreed to see me, a magnanimous gesture from on high. Her office was a shrine to control, awards for community beautification, architectural renderings of the coves, and a large window overlooking the unnaturally turquoise community pool. She was a woman in her late 50s, with hair the color of polished wheat and a smile that didn't reach her eyes, which were the pale blue of a winter sky. "Mr. Thorne, I presume," she said, not rising from her chair. "I'm glad you came. It's best we're on the same page before work begins." "There's no easement, Ms. Breckinridge," I said, placing the copies from the records office on her desk. "My deed is clear. You have no right to spray paint my land or build anything on it." She glanced at the papers as if they were a minor unpleasantness, a piece of litter. "The easement is implied by necessity and historical use, Mr. Thorne. That creek is the sole drainage outlet for the entire cove stormwater system. The primary pump at the lake is overwhelmed. We're experiencing backups. The new station on your property is a critical piece of community infrastructure. It's not a request." She folded her hands. "Surely you understand the importance of proper drainage? You wouldn't want to be responsible for flooding in people's homes." The threat was as clear as the paint on my trees. She was reframing her trespass as a civic duty, and positioning any resistance from me as malicious obstruction. Historical use? That creek has flowed naturally since the last ice age. Your system is pipes and concrete you chose to install. Your problem is not my emergency. You are not to set foot on my land. Her smile tightened. The notices have been served. The contractor is hired. The board has voted. This is happening, Mr. Thorne. You can either cooperate and allow us to create a discreet, landscaped facility, or we will have to pursue legal action to affirm the easement, and you will be liable for all legal fees and the cost of emergency mitigation if flooding occurs. I'd hate to see you lose that charming little cottage over a misunderstanding about a bit of pipe. I left her office, the taste of bile in my mouth. This wasn't bureaucracy, it was theft, dressed up in legalese and delivered with a smile. She wasn't just a busybody. She was a corporate raider of personal property, and my land was her hostile takeover target. The following Monday, they came. Not at dawn, but at a civilized 8 a.m., as if their invasion carried business hours. A convoy of trucks, a backhoe on a flatbed, dump trucks, pickups loaded with PVC pipe and bags of concrete. They rolled right past my private property sign, following the orange paint like a trail of breadcrumbs. I was waiting for them, not on the porch with coffee this time, but standing in the middle of the old logging road they used as an access point. I held my phone, recording. A foreman in a hard hat climbed down from a pickup. "Sir, you need to clear the area. We have a permit to work here." "Show me the permit," I said, my voice steady. The phone in my hand felt like a tiny shield. He blinked, unprepared for the challenge. "The HOA has it. We're hired by the HOA. This is their easement. This is my land. There is no permit from the county because there is no easement. If you proceed, you are committing criminal trespass and destruction of property. You, your company, and every man here will be named in the lawsuit." I panned the phone slowly across the idling trucks, capturing license plates, company logos, Aquaflow systems, and the confused faces of the crew. The foreman retreated to his truck to make a call. I could imagine the conversation with Karen. "He's here. He's filming. Says there's no permit." After several minutes, he returned. His demeanor had changed from officious to annoyed. "Lady says the paperwork is solid. Says to start. She's sending the HOA lawyer out. Then you'll be starting your first day as a defendant," I said. I didn't move. A standoff simmered in the morning heat. The crew loitered, smoking, casting glances at me in the woods. They were here to dig, not to fight. After 40 minutes, a sleek silver sedan pulled up. A man in a suit that cost more than my car got out, the HOA lawyer. He introduced himself with a card I didn't take. "Mr. Thorne, you're obstructing a critical public utility project." "It's not public. It's for your private community. And it's on my private land. Show me the court order granting you access. Show me the county permit." He had a folder. He showed me a document titled Declarations of Covenants, Conditions, and Restrictions for the Coves at Silver Lake. He pointed to a dense paragraph. Section 18.2 establishes a blanket drainage easement for the benefit of all lots. Your parcel, while not part of the coves, is subject to the easement as the dominant tenement in the watershed. It was gibberish. Powerful, intimidating gibberish. My deed, registered with the county, says otherwise. Your fictional easement doesn't trump my title. Now, get off my property. The lawyer sighed, a man dealing with a stubborn child. "We have an injunction hearing scheduled for Thursday. The judge will affirm the easement. If you force us to get that order, you will be responsible for our legal costs and for the delay, which could be catastrophic if we get rain. Ms. Breckinridge is willing to offer a one-time good neighbor payment of $2,000 for the temporary inconvenience if you allow work to proceed today." A bribe. A cheap one. The anger was a clean, sharp blade inside me. "Tell Ms. Breckinridge she can take her $2,000 and her pump station and put them where the sun doesn't shine. You have until the count of 10 to turn these trucks around, or I call the sheriff and file criminal trespass charges against every single one of you." I raised my phone, my finger hovering over the dial screen. 1. 2. The lawyer's composure cracked. He hadn't expected this. He'd expected fear, or greed, or weary acquiescence. He waved angrily at the foreman. "Shut it down. We'll do this the hard way." They left, the truck's grinding gears in retreat, leaving silence and the ghost of diesel fumes in the air. The orange paint, however, remained. A battle had been averted, but the war was just beginning. I knew what was coming next, the legal machinery of the coves, well-funded and relentless, grinding toward that Thursday hearing. I didn't have the money for a prolonged legal war. But I had the truth, and I had time. That afternoon, I didn't hire a lawyer. I became one. I went to the law library at the county courthouse, a musty room smelling of old paper and defeat. I researched easements, implied by necessity, prescriptive use, and dominant tenement. I read case law until my eyes burned. The key, I learned, was that an easement by necessity required there to be no other possible outlet. The coves had an outlet, Silver Lake. Their problem was capacity, not necessity. It was a crucial distinction. I also bought 2 game cameras, the kind hunters use, and mounted them high in trees overlooking the painted route in the creek bank. I emailed the video from my phone to myself, backed it up on a cloud drive, and printed still frames. I started a log, June 14, 8:07 a.m., Aquaflow Systems Truck Center property. HOA lawyer attempts coercion. On Wednesday, a courier delivered a thick packet. The motion for preliminary injunction from the law firm representing the cove's HOA. It was filled with technical jargon about hydrology studies and imminent irreparable harm from stormwater backup. Attached were affidavits from Karen Breckinridge and a hired water management engineer stating the absolute necessity of the pump station on my land. Karen's affidavit was a masterpiece of righteous concern. The health and safety of over 100 families are at risk due to the obstructionist actions of Mr. Thorne. My response, filed the next morning an hour before the hearing, was thinner. A simple affidavit from me, attaching the clean deed, the photos of the orange paint, the video stills of the trucks, and a printout of the county's website showing the coves had received no permit for work on my parcel. I cited the case law I'd found. I wore my only suit, which smelled faintly of mothballs. The hearing was in a small, wood-paneled courtroom. Karen Breckinridge was there, flanked by her sleek lawyer and a technical-looking man in glasses, the engineer. She gave me a look of icy pity. The HOA lawyer argued eloquently about community, safety, and the greater good. He presented the hydrology report like a holy text. When it was my turn, I stood, my heart hammering against my ribs. Your Honor, I began, my voice thankfully steady. This is not about drainage. This is about a powerful homeowners association attempting to seize private property because it's convenient for them. They have presented no evidence of an easement, because none exists. The necessity they claim is a financial one. They don't want to pay to upgrade their own system on their own land. They want to use mine instead. They have already committed trespass, vandalized my trees with spray paint, and attempted to bully me into submission. All I ask is that the law be followed. No easement, no access. It's that simple. The judge, a weary-looking woman with sharp eyes, asked questions. She asked the HOA engineer if there were any alternatives to the pump station location. After much hedging, he admitted, well, theoretically, the primary system on HOA property could be substantially rebuilt and expanded, but the cost would be significantly higher, and the disruption to the community. So it's a matter of cost and convenience, not absolute necessity, the judge finished for him. She looked at the HOA lawyer. You have not met the high bar for an implied easement by necessity, counsel. Your motion for a preliminary injunction is denied. The status quo is to be maintained. That means no entry, no construction on Mr. Thorne's property. If you wish to pursue a full easement case, you may, but you will do so with no work having begun. Next case. The response came from a new lawyer, the HOA's insurance counsel. It was a masterpiece of gaslighting. The association is unaware of any unauthorized installation. The pump station referenced may be related to a separate, permitted environmental remediation project. We categorically deny any wrongdoing. Any attempt to remove community water management infrastructure will be met with a counterclaim for vandalism and endangerment. Karen had circled the wagons. She was going to brazen it out. Miriam grinned when she read it. Perfect. Now we go to war. The lawsuit we filed was robust: trespass, conversion, private nuisance, intentional infliction of emotional distress, and seeking punitive damages. We named the coves at Silver Lake HOA, the Aquaflow Systems Company, and, personally, Karen Breckinridge, for malicious and tortious interference. The discovery process was a revelation. Miriam subpoenaed HOA board minutes, emails, contractor invoices. The story they revealed was damning. Emails from Karen to the board: Thorne is a recluse, an obstructionist. He'll fold if we show strength. The cost of upgrading our own system is prohibitive. His land is the only sensible solution. An email from the HOA lawyer after the lost injunction: a judicial easement is unlikely. Other options should be considered. Karen's response, copied to the Aquaflow owner: just get it done. He never goes down there. By the time he notices, it'll be a functioning part of the landscape. We'll deal with the fallout later. And then, the invoice from Aquaflow to the HOA, dated the day after the pump was discovered: emergency installation services, secondary pump station, G12 site. It listed materials: pump, concrete, hose. It was a smoking gun, directly linking the HOA to the clandestine installation. Miriam deposed Karen. I was allowed to watch. Karen, under oath, was a different woman, nervous, evasive. She tried to claim that the emergency installation was for a different site and the invoice was mislabeled. When Miriam presented the email where she told them to just get it done, Karen's lawyer objected, but the damage was done. She claimed she meant get the legal process done. No one believed her. The pressure began to build from within the coves. The legal fees were mounting, and the special assessment to pay for them was wildly unpopular. Homeowners started asking questions in open board meetings, which we obtained recordings of. A man with a loud voice demanded, "Why are we spending a fortune to steal a pump from a guy's creek when we could just fix our own damn system?" Karen's responses were brittle, defensive. The united front was cracking. Then, Miriam played her masterstroke. She had a hydrologist examine the necessity. His report concluded the pump on my land was not only unnecessary but poorly designed. Its intake was likely to clog with debris, and its installation had damaged the creek's natural bank, increasing erosion. Furthermore, he found that the cove's primary issue wasn't outflow capacity but illegal inflows. Several homeowners had illegally connected basement sump pumps and yard drains to the community storm system, overwhelming it. The HOA had been turning a blind eye for years. Miriam filed a supplemental complaint with the county environmental agency, reporting the unlawful water diversion and the creek bank damage. A county inspector showed up at the coves, and later at my creek, taking pictures and writing citations. The walls were closing in on Karen Breckinridge. The insurance company, facing a massive payout for punitive damages and environmental fines, began pressuring the HOA board to settle. The board, terrified of personal liability, turned on her. The call came from Miriam on a Tuesday. They want to talk settlement. All of it. Removal, damages, legal fees, the works. They're ready to capitulate. The settlement meeting was in Miriam's conference room. Karen Breckinridge was not there. She had resigned for personal reasons, according to the new HOA president, a harried-looking man named Doug. Their insurance lawyer did most of the talking. The agreement was comprehensive. The HOA would hire, at its sole expense, a licensed contractor to remove the pump, concrete pad, and all associated equipment from my land within 10 days. A restoration expert would return the creek bank to its natural state, using native plants. They would pay me $75,000 in compensatory damages for trespass, conversion, and emotional distress. They would pay all my legal fees, which were substantial. They would record a permanent, irrevocable deed restriction at the county, forever renouncing any claim of easement or right to enter my property for any purpose. Karen Breckinridge would provide a written, notarized apology, to be included in the court's final order. I signed. A week later, different workers, under my watchful eye, and removed the offending machinery. The concrete was broken up and hauled away. The creek bank was reshaped and replanted with willow saplings and sedge. The check cleared. The deed restriction was filed. Karen's apology letter arrived, a cold, formal paragraph that held no remorse, only the bitter acknowledgement of defeat. I framed it, not as a trophy, but as a reminder. The final act was a quiet one. With the settlement money, I hired a proper surveyor. Together, we cleared the old stone wall boundary line. At the corner where my land met the community, where the orange paint had first appeared, I didn't put up a fence. Instead, I planted a row of eastern red cedars. They were native, fast-growing, and would form a dense, evergreen barrier. A living wall, rooted in my soil, reaching for the sun. They would, in time, become the only statement I needed to make. One evening, months later, I walked down to the creek. The restoration was taking hold, green shoots covered the raw earth. The only sound was the water and the wind in the trees. The land was healing. The line was held. I had learned that some people see a boundary not as a limit, but as a challenge. And I had learned that defending what's yours isn't about anger, but about a patient, unshakable resolve. The pump was gone. The peace, at last, was my own.